The following program is made possible in part by the Dayton Bar Association.
Good evening. My name is Jeff Swillinger. I'm an attorney in the Dayton area, and I welcome you to this month's edition of You and the Law. I am filling in this year for the long-standing host, Mike Monta. Mike's decided to take a little time off this year. We are a one-hour call-in show. Our topic this evening is landlord and tenant law. That was our topic last month. That was my first show. Our guests are Steve Katchman, attorney here in the Dayton area, as well as Debra Lavey, also an attorney here in the Dayton area, both very fine lawyers. Steve is in private practice, and Debra is with what is affectionately generally called legal aid, but more specifically LAWO and ABLE Legal Aid of Western Ohio, and Advocates for Basic Legal Equality. Steve's office is downtown. Debra's office is also downtown. There are numbers that will appear on the screen. That number here is the call-in number for the show. Please feel free to call in, and we'll discuss landlord-tenant law generally, although we're going to pick up tonight where we left off last month. However, some of the topics that we addressed last month were related to what would happen if a tenant wanted to lease a residential property, a home or an apartment, and we picked up from there what the process would be, what some of the complications could be if the landlord and the tenant were not on the same page. If you have questions about those kinds of issues, even though we're not going to rehash that again this evening, you're more than welcome to call in. In the meantime, while we're awaiting calls, Deb and Steve will help us transition to tonight's subject matter. So with that, we'll get started. Deb, good evening, welcome. And Steve, good evening, welcome.
Thank you.
Thank you.
As I said last month, we talked a bit about the obligations of landlords, the obligations of tenants, arising out of a hypothetical situation where a tenant might come in and want to, let's say, rent an apartment in the greater Dayton area, and what might be involved in that. We had discussions about leases. We had discussions about what kinds of problems could arise, the need and wherever possible to have representation when you're entering into a lease. And those types of topics. We talked about some of the problems that might occur in the event that there is a dispute between the landlord and the tenant. And we will pick up with this subject matter, I guess, about at this point now. I'll leave it up to one of you to tell me who agreed to go first this evening.
Yeah, so Jeff, it's good to be here.
Thank you. Welcome.
So last time we sort of ended talking about the eviction process and what happens when a landlord decides that he or she wants a tenant to leave. Tonight we thought it might be helpful to talk about what a tenant might do if they're having problems with their landlord. Specifically if they're having problems with conditions at the property that materially affect their health and safety. So there's a process in Ohio called rent escrow. It's a process designed to give a tenant a remedy if there are conditions at the property that materially affect health and safety. Now, I've said that statement twice, and I've said it twice for a reason, because rent escrow is only designed to address conditions issues that do affect health and safety. So it's, for instance, an example might be a tenant doesn't have hot water any time of the year. They don't have heat in the winter time. Maybe they have a big gaping hole from the roof that's bringing water in. Those types of issues are the types of issues that rent escrow is designed to resolve. They're not designed to resolve aesthetic issues, like I don't like the color of the paint in the living room, or I'd like different carpet. We're not talking about carpet that has holes in it. We're just talking about I don't like the pattern of the carpet. So the rent escrow process is meant to be tenant friendly. How the process is designed to work is that a tenant is to notify the landlord of a condition that materially affects health and safety. Generally, we suggest they do that in writing. In today's technological world, that can happen in a number of different ways. Historically, when I started, it was through a letter. Today, it can happen through a text message, an email, other forms of communication, but typically we suggest in writing that they give the landlord notice of the issues that need to be addressed. And they give the landlord a reasonable amount of time to make those repairs. Typically, a reasonable amount of time is 30 days. Unless they don't have hot water or they don't have heat, that could be a significantly shorter period of time, just a few days. If the landlord fails to remedy the conditions within that reasonable amount of time and the tenant is current in her rent, she can then go to the local municipal court where the property resides. So if you live in the city of Dayton, that'd be Dayton Municipal Court, and file a rent escrow action. There is no cost for filing the escrow action. However, the court may assess costs at the end of the case, which is typically 1% of the cost they can hold back for processing. And that's how you would begin the case.
Now, I think it's important to point out that we left off last month where we were talking about the landlord choosing to or electing to file an eviction complaint and the tenant responding to that complaint. If I understand you correctly, a rent escrow action is initiated by the tenant and does not require the landlord to first file an eviction action against them in order for the tenant to act if they're having this kind of problem. Is that a fair statement?
That's correct. A rent escrow action is a separate action. It's still a civil action, and it would be filed in a municipal court in the civil division, but it would get a separate case number from an eviction case. So sometimes, without getting into too much complication, it's possible that you would have an eviction case and a rent escrow case going on at the same time with different case numbers.
And just one thing before you move on, because I've seen this in a number of different contexts, not necessarily in the landlord-tenant context, and that is the issue of writing that you talk about. Putting something in writing. Now we have text, all forms of social media, and we have certified letters, but that costs money. But we always have the problem with being able to confirm the tenant that they did this, and the landlord receiving it in a reasonable fashion. Do you have any suggestions before we move on about how you have found this to be most successful so that the two parties can actually communicate with each other?
Yeah, so generally speaking, we suggest that tenants do it in a letter format and they send it certified mail, return receipt requested, so that they have proof that they sent it. Of course, they would keep a copy for themselves and proof that the landlord received it. Tenants oftentimes use technology to send the notice, whether that's text or email, and through that process, typically you can have some way of confirming that the other party received it, but it's a little bit more challenging. And then sort of a third option is actually hand deliver it with a witness, but then you would need the witness to potentially testify that you did serve the landlord.
Steve, do you want to comment on that before we move forward? Add anything to what Deb has said, anything that landlords that you represent or property management companies, what problems they might have had with receiving notice in this context?
I think Debra explained it quite well. It's not unusual, well actually I should say it would be a bit unusual, although it would be the appropriate vehicle would be by certified mail. That way you have written proof that the notice, because I believe the statute requires that the notice as it comes to these alleged maintenance issues that might be affecting habitability be reduced to writing. Okay. So the proper form, the best way would be through certified mail or hand delivery, but as Debra mentioned, if that was ever challenged, you might want to have a witness. More often than not, whenever I have a landlord-tenant situation involving a rent escrow case, and I inquire of my client, did you get notice of what the maintenance issues are? They typically will say yes. It could also be in the form of requests that were entered to the maintenance company. You know, there's a log, and it wouldn't be unusual for an attorney such as Debra, through discovery, to request, you know, what were your written logs about these dates in question as to the maintenance issues and so on and so forth. So I typically don't run into a problem with the written part. Sometimes it's more of an issue of the content, as Debra alluded to earlier, what exactly it is that the tenant is complaining about. Sometimes it could be the carpet isn't the type of carpet I like, or it could be something, the screens don't fit the way that I'd like them to fit, or the door, the lock on the back door doesn't work as well as it should. Issues that perhaps may not give rise to a habitability concern, but I more often than not find it's a content issue, although at times it is a notice issue, but it's mostly what's in the notice that's going to draw the battle.
And I also guess that there are a lot of situations where even before the action is filed, the landlord's on notice, and that gets back to the log. If they've been called about something, the tenants come into the office, some record's been made. So there's usually a track record of some type of at least initial complaint.
And there could be a give and take from the landlord. The landlord will sometimes explain that they've tried to get into the property to fix or remedy the condition, and the tenant either won't let them in, or the tenant has dogs or things like that. So then you get into access to the actual unit that could cause some problems. But so rent escrow is a very interesting area of the Landlord Tenant Act, because there are a lot of issues that feed off that statute. And the reason we chose this topic is we both frequent court quite often in landlord tenant court and eviction court, and it's not unusual that a tenant will appear and make mention of maintenance issues. But unfortunately, because he or she didn't take the appropriate steps to escrow rent, the court simply can't consider that particular issue at that point in time, and they get evicted, more often than not.
And so it may boil down to, did the tenant pay their rent or did they not? Or were they timely about paying their rent? Did they comply with the terms of the lease, but they don't have a voice on that issue?
They have to be current with their rent. They have to deposit the rent in a timely manner. And then you get into the other issues. Well, is the rent escrow action appropriate in terms of the content, and do the maintenance issues give rise? But to at least get you going, you have to at least be current with your rent and get that properly filed with the court, correct?
Yeah, so let me back up just a little bit, because I sort of jumped right into rent escrow. Rent escrow generally applies to most rental properties, although under the statute, if a landlord owns 4 or fewer rental properties and they notify the tenant of that, then the tenant is not entitled to file a rent escrow action. So they would have to put in their lease or something like that. I own 4 or fewer rental units, and
it's rental units when you say properties.
Yeah.
4 or less units.
Correct.
Now, a unit might be 4 units in one building.
That's correct.
But if the tenant owns one building, and it has 12 apartments, that's more than 4.
That's correct.
Okay.
And it's not just enough that they own 4 or fewer, but they also have to put the tenant on notice of that. So very rarely do I come across a case where they've done that. But I have in my career at least seen one. I had one case where the landlord did notify the tenant of that. The second piece that Steve mentioned, which is important, is in order to begin the process of actually escrowing the rent with the court, the tenant must be current in their rent in order to do that. So if they're behind in their rent, they're not able to escrow. Escrow was established to address tenants' conditions issues and give them an opportunity to not pay their rent to the landlord, but to pay it to the court, so the court could help them resolve the conditions issues. So when you were talking about a non-payment of rent case, what often happens to tenants is that they don't file an escrow case, they complain to the landlord, then they don't pay the rent because of the conditions issues, and then the landlord starts the eviction process. So that's really unfortunate, because the tenant may very well have valid reasons that they didn't pay their rent, but in Ohio, they're supposed to avail themselves of the rent escrow process. I do want to mention just in passing, though, that if a tenant doesn't avail themselves of the escrow process and there are severe conditions issues, they may bring them as counterclaims. And if their claims,
If there's an original complaint to evict them, as a counterclaim to that complaint.
yeah, so if there's an eviction complaint filed against them, they may bring counterclaims related to the conditions issues. And if the amount of their counterclaim either equals or exceeds the claim by the landlord, they can argue that there's a set-off and that they're able to stay. So it's a difficult argument to make, and you would have to have proof as to the amount of your counterclaims, but it is a possibility.
Is that discretionary with the court to allow that?
No, so the set-off is, there's a statute that talks about that.
Okay. Steve, you want to add anything, or should we move on?
We can move on, but that's in a nutshell, rent escrow is, and I would also, just to piggyback on what Debra has commented, from the landlord's perspective, I actually think the rent escrow statute is a balanced vehicle. I think it accommodates the tenant in situations that truly justify perhaps court intervention to right a situation, but it also forces the tenant to comply with the law and the statute and pay the rent. Instead of paying it to the landlord, they're paying it to the court, but at least the court has the funds. And if there is a genuine dispute as to maintenance issues, then it can get resolved through the courts, and the funds could ultimately, more often than not, be released to the landlord. So I think it's actually a really good, it's a good part of the statute that we have in Ohio.
And if they go, pardon me, if they go to initiate, the tenant goes to initiate this downtown in the Dayton Municipal Court, they would go where? To the clerk's office, civil division?
Correct.
Okay.
Yeah.
First floor?
First floor.
Right.
And once they initiate the escrow action and they pay their rent to the court, and they need to do that on time and in full. So if rent's due on the 5th, they have to pay it to the court by the 5th in the full amount of rent. There can then be a hearing, and at the hearing, the court can provide a number of different forms of relief. So one, the court could release the funds to the tenant to make repairs. They could release them to the landlord to make repairs, or they could also allow the tenant to terminate the tenancy. So sometimes the tenants may just want to move, but they're in the middle of the lease and they're hesitant to move for reasons that we talked about last time, that they're going to get stuck with owing the landlord a bunch of money. So the court does have the ability to terminate the lease. And then they also have the ability to provide relief for the landlord, and Steve can talk about that.
But the tenant, they can't have all those. They can only get one. So for example, they might have a situation where the funds, in exchange for the repairs being done, then the funds, upon adequate proof to the court that the landlord has complied and has remedied the problem. For example, there may be a flooding issue. There may be water that's getting into the apartment, causing the carpet to be wet and perhaps mildew and such, perhaps even mold. That would give rise to habitability. I believe there's case law that clearly says that. It's not a question, gee, I don't like the carpet color. It's, gee, the carpet's been damaged due to some flooding issues. So the landlord would be obligated to remedy that condition, again, consistent with an appropriate escrow filing. And upon the court's satisfaction, could order that the funds be released to the landlord for the rent, in exchange for, of course, for the remedies being, for the property being repaired and the conditions being remedied. But as Debra mentioned, it could be a situation where the court or even the parties might agree this relationship is just maybe better off just terminating it, and the court or the parties might agree as well to just terminate the lease, release the funds that the court is holding, maybe to the landlord, maybe a portion to the landlord. I had a case about a year ago where there was a settlement as to that, into that effect, and then the parties just go their separate ways. So there are options that the court has, but not only the court, but the parties can, in terms of a settlement, to bring the matter to an appropriate resolution as well.
Okay. Well, let me just ask a question then before we move on. And I don't want to mix apples and oranges here, but it's my understanding that where there's an eviction, a completed eviction, the tenant who's been evicted may have some difficulty finding another place to rent in the Dayton area, for instance, because they will be questioned about this eviction. This notice of the eviction is a public record, and landlords pay attention to that in many, if not most cases. Now, in this situation that you just described, where there is a rent escrow case that results in the tenant moving on, they just decide this is not going to work out real well, both sides are in agreement, the tenant moves on. What happens to the rent escrow case? Is it dismissed? Is any relief given to the tenant? What if they've had damages? Did the damages have to be satisfied? And in the case of the landlord, if there's no proof of the damages, and the landlord just says, look, but we can't agree on this, why don't you move? Are they on the bad boy or girl list then when they go to look for an apartment somewhere else?
Yeah.
Well, just briefly, typically when a rent escrow action is initiated, and every court seems to be different. Some courts will, as Debra mentioned, will set it for a hearing. The court will initiate a notice, and there'll be a hearing for the parties to come to court and argue their case. But some courts will wait for the landlord to file a motion to request that the funds be released because they've complied, or they question the appropriateness of the rent escrow action. So depending on the court, but one way or the other, whoever initiates what first, there will be a hearing. And ultimately, the matter would be resolved through some form of an entry. There could be an agreed entry of the parties where the lease terminates, funds go to plaintiff, or rather funds go to the defendant landlord, or a portion. Right, or a portion could maybe be retained even by the landlord or the tenant, the other a remaining portion to the landlord, and then perhaps a specific date as to when the lease would terminate. It just depends on the parties, but typically, I believe, to answer your question, it would be reduced to some form of an entry.
Okay.
Yeah, and I would just like to add that an escrow case is really a case of somewhat limited relief. And what I mean by that is that the escrow statute wasn't designed to provide complete relief. So that if a tenant complains, let's take Steve's scenario, that there was a flood or there was some water and the carpet was ruined, and because of the mold, the tenant had bad asthma, other health conditions, maybe their personal property was destroyed. The escrow case is only designed to resolve the actual condition of the unit. It's not designed to provide relief to the tenant for issues that are related to them. So the tenant wouldn't be able to get relief through an escrow case for the loss of personal property or health-related issues. That would be a separate case that the tenant would have to bring.
And they need to bring a separate civil action, either in the municipal court or the common police court, depending upon the amount of damages they're claiming, I assume, relative to their personal property or any personal injury that they're claiming that they, let's say they claim there's a mold issue and that they've been personally damaged because of that.
That's correct. Just for example, if the court would order that the tenancy could be terminated through an escrow case, and then the landlord claims that there are damages at the property that exceed normal wear and tear, and it's more than the security deposit, they'd have to file a new action or an action against the tenant to get that money. That wouldn't come out of the rent escrow case.
Okay.
That's a very good point.
Okay. Well, once again, this is another example of something we've been talking about from the beginning, including last month, and that is the importance of, if possible, having representation in these cases, because the devil's in the detail, and for both sides to really get their day, whether it's in court or out of court, it's helpful to do that. And I understand that sometimes, particularly for the tenant, that's a problem, which is why making application to a law will able, and I believe that number is on the TV screen, but just in case it's not, Deb, would you provide that number if a tenant has a question or they're seeking relief, what that number would be?
Yeah, absolutely. So if I work for Advocates for Basic Legal Equality, and our sister organization is Legal Aid of Western Ohio. We provide free legal services in civil cases for low-income individuals and for folks that are 60 or over. If folks need help, they can contact our office at 1-888-534-1432. We take calls Monday through Friday from 9 to 2. That's our legal aid line hotline. They can also walk into our office and complete an application at 130 West 2nd Street, Suite 700, or they can apply online at www.legalaidline.org. And I just want to mention that we do have a special grant to help folks that have been served with evictions in Dayton Municipal Court. It's through the Ohio Legal Assistance Foundation, so folks are welcome to call if they need assistance or apply any of the ways I've mentioned.
And you have a website also. This might be a good time, right? Not you personally, but Law will enable have a website. How do they access that?
So typically they can access it through the www.legalaidline.org. That will take you to our website as well.
Okay. I think that's important because that's a common thread throughout everything we're talking about. Steve, why this might be a good time. Let me just say one thing. I want you to talk about where your office is and what your phone number is. I know you represent generally landlords or management companies, but I'd still like you to get that information out there. Maybe some potential landlords would like that information.
No, I appreciate that, Jeff. Yeah, my office is downtown. I'm in the Barclay building, at least for the time being, until it gets converted.
Okay.
It was recently, as I think many people know in the Dayton area, the building was recently sold. So it's a very nice building. But my number is, of course, 937 area code 222-4301. And I would just note that when it comes to rent escrow issues, regardless if you're a landlord or tenant, I would encourage you to get legal advice. And I don't mean that to be as a self-serving comment. It can be a complicated statute to navigate, in particular if you're a tenant, because there are requirements that you would have to meet to engage a successful rent escrow action. So I would encourage legal assistance if possible.
And I think you'd agree with me. If not, you're free to disagree that it's not so self-serving in the sense that, for all the reasons that have been discussed, that these oftentimes are complicated matters. And sometimes it's good if somebody can afford to just get a consultation and see what they're up against. Now,
Correct.
That's generally the paying client, as we know, who has the resources to do that. But that doesn't necessarily mean you're going to handle their case. It doesn't mean you're going to handle the whole matter, but it's a good idea for them to at least get some advice and to call your office, I suspect, for instance, or some other attorney. This is
Certainly.
that you're not here tonight other than contributing your time here. You're not here tonight to talk about your practice per se. But I appreciate your being here and want folks to hear your good advice. And Deb, at the same time, I think if we could get back to when someone calls your office, they're not necessarily going to speak with Deb Lavey. In fact, generally they're not. The first time they call, they're probably going to speak with a paralegal who screens the cases. Is that right? Why don't you talk just a little? Because I know that over the years, expectations of calling legal aid, as we call it generally, and what it used to be called years ago, and people have an expectation they're going to speak with an attorney the first time they call, or maybe get a call back that day from an attorney, but you have such a volume of cases and all different kinds of cases in your office, some of which you can't even take. What can they expect before we go further on the substance of the evening? What can they expect when they call the office just as a procedural matter?
Great question. So if folks call our legal aid line number, what they can expect is they may have to leave their name and their telephone number, and then someone will call them back. Typically, they make those calls back within 24 hours. The number that the caller will be coming from will come up as a block number. So I think that's important. Sometimes folks screen their calls for a variety of reasons. I know sometimes I don't take what I perceive as telemarketing calls myself at home, so they should expect that it will come from a block number and they should answer that call. If they apply online, someone will contact them by phone And then if they come into the office and walk in, they'll be put into an office and they'll talk to someone on the phone. What they'll initially do is be screened by an intake specialist for, their name and their address and their income information and what their issue is. And they'll determine whether or not it's a case that we can either help with and or if they're income eligible. Once they make it through that screening process, they'll either be assigned to a lawyer who will give them information over the phone and through the mail, or they'll be referred to a local office where they'll get what we would call full service, which may include representation in court on a case.
Okay. And we shouldn't overlook the fact that there may be individuals who are tenants who go to a private attorney such as Steve to represent them on the tenant side. Not just landlords are represented in these scenarios. And private attorneys can do this type of work also, and it just depends on what the problem is and whether the private attorney and the prospective tenant can reach an agreement on the representation, I guess. So you provide a service, the private attorneys provide a service. You have a website. Are there materials on the subject matter that we've been discussing, landlord tenant law last month and this month? Are there materials on your website that people can look at about landlord tenant law? And Steve, I don't give you the same question, but since I was asking Deb first.
So our website is in the process of being updated. I'm not sure that there are materials regarding the landlord tenant law on our website. We do have a great booklet that is available in our office.
What's that say? Your rights and duties as a tenant from Law, Woe, and Able.
Yeah, and it has a lot of information on rent escrow and the eviction process, stuff we covered last time, material we'll cover this time, I imagine. So that's a great resource that we can send to folks. There's also a good website in Ohio. It's the Ohio Housing Locator website. It's www.ohiohousinglocator.org. That's a great place for folks to look for rental properties, tenants particularly, whether it's subsidized or it's private. And then there's just good materials on a variety of landlord-tenant issues on that website.
Okay. And folks, if you have not been able to write that down, or there are other numbers on the screen you maybe haven't been able to take down this evening, this show will be, this probably a good time to say this show will get to YouTube probably in the next 48 hours, I believe. And you'll be able to take a look at it and fast forward to the point where you need to get those numbers. This is also a good time to remind you that this is brought to you by the Dayton Bar Association, who has underwritten the show, and the fine work of the staff and volunteers here at DATV. Let's move on. And again, the numbers I see on the screen here, that's for the Dayton Bar Association and the lawyer referral service of the Dayton Bar Association. If you call that top number that ends in 7902, that'll get you to any of the departments of the Bar Association, and the Bar Association also has a website there. Why don't we move on?
Yeah, so one of the things we talked about in the rent escrow process was the ability for the court to terminate the agreement between the parties. And under Ohio law, sort of separate and apart from the rent escrow process, the law is set up that either a landlord or a tenant can non-renew their tenancy. So last time we talked about lease agreements in Ohio, they can be in writing or they can be oral. And typically if they're oral, the tenancy is determined by the payment of rent. Most tenants pay their rent on a monthly basis. So if they pay their rent on a monthly basis, they're considered a month-to-month tenant. And under a month-to-month tenant agreement, either the landlord or the tenant can decide to non-renew the tenancy by giving a 30-day notice or a month's notice. And they would do that by typically doing it in writing to the other party saying, I'm not renewing the tenancy. The challenge that we often see is that landlords and tenants sometimes get confused as to what 30 days is. So, for example, if rent is due on the 5th of November, today, right? And they pay their rent and they decide, I don't want to renew my tenancy, if they give a 30-day notice now, typically they're going to need to wait a full month before the tenancy would end.
The full month of December in this scenario?
So,
Or the full month of November that they just paid for?
so this is where it can get a little tricky, right? Typically, let's say they pay it on let's say that rent is due on the 5th and they pay it on the 5th and then they don't give their notice until the 5th. Typically, I would argue that the notice won't be effective until the end of December. So they would have to give a full 30-day notice. If they gave it at the beginning of November, then they could leave at the end of November. And so that's where it often gets complicated with landlords and tenants.
So it may not be the date that the rent is actually due. So they should do it based upon a calendar, 30 days, starting with the first of the month, is what you're saying. If their intent in this scenario of being out at the end of November, they're paying the last payment will be just for November, want to be out in December, give your landlord notice in writing, hopefully certified mail, so that you can prove you gave notice on that date, and then they have a better shot at getting out when they want to without owing them their next month's rent. Is that affected at all by a provision in the lease that gives them a grace period? Or does that apply regardless? If they give notice on the 1st, if the lease provides, well, your rent is due the 5th, but you have a grace period of, let's say, 3 days, maybe the 8th, that really doesn't affect anything you said, no.
Generally speaking, it doesn't. And often where we see this being a problem is where one party, the scenario I gave is a little bit more complicated, but if a party gave their notice in the middle of the month and rent was due at the beginning of the month, so let's say November 15th, saying I wanted to leave at the end of the month, the tenancy wouldn't terminate until the end of December because clearly there's less than 30 days remaining at the end of the month, right? There's 15 days. So that's, tenants and landlords have a right to terminate a tenancy with the appropriate notice. Sometimes landlords and tenants have a week-to-week tenancy where rent is paid once a week. And with those types of tenancies, they can just give 7 days notice to non-renew.
But if you pay it on Wednesdays, you should give your notice on Monday, I imagine.
Yeah, if you're wanting to move out.
The day before you would pay your rent.
Yeah.
For the rest of the week.
If you're wanting to move out
early. If you're wanting to move out early. Steve, what are some of the issues from the landlord's point of view in these kind of situations?
It is. As Deborah mentioned, it's tricky, and I get these questions quite a bit. The lease, if there is, assuming there is a written lease, will typically address holdover tenancies, meaning after it goes beyond the original term, the tenant, they carry over it's a month-to-month relationship. And the law clearly allows either party. It's a reciprocal requirement. You just have to give notice. Typically, it's going to be a 30-day notice because typically that's the tenancy relationship, 30 days. But what gets tricky, as Deborah mentioned, what if the tenant pays on the 5th of the month and you want to, and sometimes the landlord just is anxious. They want to move them out as soon as possible. They accepted rent. Do they have to wait? And I prefer that they just start on the calendar the 1st, of course. Sometimes they'll serve a notice in the middle of the month, so you have to carry it from the middle of the month to the middle of the next month. And oftentimes I'll say just start, if they're still there and you have to initiate an eviction, just wait until the beginning of the next month. It just eliminates confusion and so on and so forth.
So it's the devil's, again, always in the detail. So here, let's stick with the facts that we just were given. We have a lease that provides payment on November 5th. The tenant wants to be out at the end of November. The tenant should give notice to the landlord in writing on November 1st, best case scenario, and pay their rent by the 5th of November, and then be out by November 30th.
Correct.
To avoid a conflict. Now, let's suppose the rent is payable on the 15th of the month. Now, does that change anything based upon what Deb said as far as whether it's the 5th or the 15th? Do you get 30 days from the 15th and now it's the 15th of December? Or are we, if they gave notice on the 1st of November but they don't pay the rent till the 15th, what happens in that scenario?
Well, I believe it's going to be 30 days regardless.
So-
if they tender payment and it's accepted in the middle of the month,
And it's the middle of the month of the following month.
right, it's going to be the
Before
following.
they get out.
Right, I just think it's easier
Okay.
to just start, if you're the landlord, if you're going to serve a notice, serve it on the first day of the month rather than the middle or the, now what they will do too sometimes is, they'll prorate, but you're better off just trying to keep it, it's cleaner and simple or simpler to just start at the beginning of the calendar month. But sometimes it just doesn't work out that way, whether it be with the landlord or the tenant.
What happens when the tenant comes in? They were ambitious about getting out on the 30th in our scenario. And they come in on the 29th of November and they say, I've had some health problems. I really don't think I can get out till December 5th. And what if the landlord says no? What if the landlord says yes?
Well, sometimes the landlord will say, fine, just pay rent through the 5th, right? And then sometimes it could be maybe not so easy, and then the landlord could initiate a 3-day notice after that 30 days has come and gone.
Is there any
For
scenario?
non-payment of rent, if no rent is paid.
Well, from the landlord's perspective in this situation, then what happens if they give them until the 5th? Can the tenant argue they've created a whole new 30-day period?
I'm sorry,
If the rent was paid through the 30th of November,
correct.
the tenant comes in on the 28th, says, I need a few more days. The landlord says, okay. Then the tenant's not out on the 5th. Tenant says, this is a whole new period of time, and I've decided I want to stay 30 more days. Does the landlord have a right to evict them at that point, or can the
Well,
tenant, as long as they pay their rent?
If the tenant has paid rent,
Mhm.
then the landlord is in a position they would have to, in my opinion, would have to serve a 30-day notice because they've accepted rent, provided they hadn't already, if the tenant, from your fact pattern, is who's been initiating the 30-day notice.
Okay.
I want to move, I'm going to be out by a certain date. Well, I can't be out by this certain date, I need some more time, pays rent, and it's accepted. And then the landlord turns around and says, you know what, I really think I want this tenant out, if I'm following your fact pattern.
You see, because in my experience, these things
I think
oftentimes
at that-
don't run smoothly.
No,
There's a
more often
change-
than not, they don't.
There's a change in midstream. I'm
Right.
not attributing it to one side or the other.
Right.
But how do you deal with that?
So in a situation like that, though, I believe the landlord would now have to initiate a 30-day notice of his own, and then give the tenant 30 days to vacate, and then if the tenant doesn't vacate, then he or she could then initiate a 3-day notice and proceed with an eviction. But you're not going to be accepting rent once that 3-day notice is served or issued. But I think the ball now shifts to the landlord.
Yeah, and I think just Steve's point was well taken. I think this is a good place to talk about self-help evictions.
Okay.
What the landlord cannot do is get frustrated and change the locks legally. So you said you were going to be out. The tenant's clearly still there. Their stuff's there. They're coming in and out of the unit. The landlord is not allowed to change the locks as a way of getting the tenant out unless the tenant has completely abandoned. And typically, the only way you can prove abandonment is that there's an intent on the part of the tenant to abandon, and there's evidence of that. They've returned the keys is one of the clear ways that you show abandonment. So the landlord shouldn't change the locks, they shouldn't shut off utilities, they shouldn't take any of the tenant's personal property in a way to get them out. That's called a self-help eviction, and under Ohio law, it's prohibited. The landlord could be subject to a case for damages and attorney's fees, and in extreme situations, potentially punitive damages. It can be very costly.
Are we talking since we've been talking for the most part since last month about residential eviction, It's a little different scenario potentially in a commercial eviction case as far as self-help, right?
That's correct.
Okay, so we won't get into that, but I just want to make that clear for anyone watching us that we're talking about residential evictions here when this advice is
Correct.
being given. Okay.
Correct.
Okay.
It's an entirely, it's a different environment when you're dealing with commercial leases. But Debra makes a very important point, specific to landlords, because landlords, especially if they're not very familiar with landlord tenant law, are not very sophisticated in how the law works and operates, they may think they can just go in and change the locks, and sometimes it may not even be under your scenario. There may be a period of time has elapsed, they haven't seen or heard the tenant, they drive by the property, they don't really think they're there, they're not really sure they're there, they see some items in the property, and they just go in though and they think they're gone, they change the locks and do whatever, and the next thing you know the tenant shows up, I just happen to be out of town. So now they've exercised a self-help action that could get them into some problems with the law. So they need to be very careful of what you do.
Yeah, I've seen real extremes. I've seen landlords who have a written lease. They don't like the way the tenant's been behaving during their tenancy, and they just tell them you have 3 days to get out. And tenant says, I have a lease, and the landlord said, I don't care. Okay? Then get a lawyer, because in 3 days, you're out of here. And I've seen other situations where the tenant's pretty savvy about how to work the notice. And back to the questions I was asking you, and it seemed a little complicated, and it seems to me it gets to be where the rent's due on the 1st, or the 15th, but you give notice on the prior 1st, and then you ask for a little bit more time, and then you start asking for a little bit more time each time you're given a little bit more time, and the next thing you know, tenants, they're 3 months in, the landlord had made up their mind that when they first gave notice, that's fine, you can leave. So I've seen both extremes, and
Sure.
that's why, again, it's important, I think, to get advice if you can from counsel wherever possible, and that's really important. Okay, where are we going to go from here?
I think the other point that we wanted to mention is that under the Protecting Tenants and Foreclosure Act, there may be a longer notice that might be required. So as most folks remember, we had a huge foreclosure crisis across our nation, and Ohio was hit particularly hard by the foreclosure crisis, where millions of Americans lost their home to foreclosure. So sometimes tenants would be renting those homes. And in 2009, President Obama signed into law the Protecting Tenants and Foreclosure Act. That law was in effect for a number of years, and it ended sort of on its own. It had a sunset provision. But back in June of this year, Congress revived the Protecting Tenant and Foreclosure Act. And just the important piece under that act is that if you're a tenant and you're renting a home that goes into foreclosure, and someone purchases the home, whether it's the bank that buys it back or a third party that purchases the property, the tenant can't be removed from that property by the new owner giving basically a 3-day notice. We've talked about the 3-day notice last time. They would have to give a 90-day notice under the Protecting Tenants and Foreclosure Act. The purpose of that is to give the tenant ample time to find another place. Years ago, there were horrific reportings of tenants not knowing that the property went into foreclosure and being locked out with absolutely no notice, and in some situations, tenants taking their own life because they were just so grieved by the whole process. So the PTFA is an attempt to balance that and provide sufficient notice so that the tenant can find another place. So that's important to note.
Do actions under that act engage potentially other types of representation if you are seeking some type of relief under federal law instead of state law? Is there any other representation available, or conversely, does your office take those cases even if they might be an action under federal law rather than state law?
Yeah, so even though the PTFA is a federal law, it applies to eviction proceedings in state court. So we represent tenants in eviction cases, and there very well may be a defense under that law if the landlord did not provide the appropriate notice.
You want to comment on that statute? We have about 5 minutes left, and I had a couple other questions I want to touch on. But
Jeff, I have not had a case where I've had to represented a landlord under that particular statute, but I am familiar with it, and I understand the 90-day notice and why the statute was enacted, but I have not actually had to litigate that issue.
Okay. Let me make a point here, and then I want to get back to a couple last points. Ladies and gentlemen, tonight's show and each of our monthly shows presently are viewable on Channel 5, Spectrum Channel 5 in the greater Dayton area, and in Riverside, Channel 6 in the northern suburbs. We're still working on expanding the scope to other areas. I don't have any more information to provide on that this evening. It's also live streamed, and as I mentioned at the beginning of the show, you'll be able to view it on YouTube probably in the next 48 hours. Let me ask you a couple other questions before we go. Two issues. Security deposits is one issue. Let's start with that and see if we have time for another issue. I think, again, my limited experience in this area, security deposits is often a hot issue. Steve, why don't you go first on that? As far as the provision of a security deposit per lease, when is the tenant entitled to their security deposit back? When are they not? I understand it's not always a hard and fast case.
No, it's not. The typical battle in a security deposit scenario is what the tenant's entitled to, of course. But there's procedures that are particular to the landlord that they have to pay attention to. And that would be when a tenant vacates, that the landlord has to provide an itemized statement, for lack of better words, itemizing the security deposit against whatever charges might be due and owing the landlord. It could be in the form of background, it could be in the form of damages to the property that go beyond the scope of normal wear and tear. And the landlord's obligated within 30 days upon the tenant vacating to provide an itemization of that, an itemized statement, essentially explaining the disposition and where the security deposit is going. Either hypothetically it's a $500 security deposit, and why is a tenant only getting $200 of it back, or if maybe not getting any of it back. But there's an important provision, and the statute requires the tenant to provide either a forwarding address or a new address to the landlord in order for the landlord to do what the landlord is required to do under the statute. And if the tenant doesn't do that, he or she may not be able to recover in court those funds that they believe are due and owing.
Is there a sunset provision where if the tenant doesn't take the proper steps, but then they get an attorney maybe 3 months later and they decide they're going to go after, they barred by any statute from going after 3 months later, 6 months later, maybe their security deposit?
I don't believe there is. I mean, when I see it, it typically comes up in a collection case. Okay. And the collection cases, by statute, if it's a contract, could be 8 years.
Okay.
So it typically comes up in that context. And so the tenant will raise as a counterclaim they didn't get their security deposit back and they're entitled to that plus fees, attorney fees, and so on and so forth.
Okay, thank you. Deb, do you want to add anything to that relative to security deposits?
Yeah, I would just mention very briefly, some of the triggering issues is that the tenant has to return possession, which means return the keys. That triggers the security deposit provision, and then that starts the 30-day clock. If the landlord would wrongfully withhold the deposit and the tenant has returned possession and provided a forwarding address, the tenant is entitled to sue the landlord for the tenant could get double the amount of the deposit that the landlord wrongfully withheld plus their attorney's fees.
Okay, thank you. Now, we've got just about a minute left, and there's so many different subjects related to our general topic tonight. Reasonable accommodations when someone has some type of disability and they want to move into an apartment. Therapy animals. We haven't talked about that type of situation, in situations where landlords might not otherwise allow pets. What are the circumstances where they might be obligated to do so? Retaliation by the tenant or the landlord in a situation, and how that impacts upon the relationship. A lot of other things, subsidized housing, and how the rules and regulations we've been talking about these last 2 months are impacted by a different framework when you get into federally subsidized housing issues, and who's eligible and who's not, and all the different eviction steps, are they the same in those contexts, and so forth. So maybe if you're kind, I'll get a yes, and maybe sometime later in the year we'll see. Maybe we get you back and we can kind of finish those. But I think we're just about done for the evening. I want to thank Steve Katchman, private attorney here in the Dayton area, and Debra Lavey from Law Will Able Legal Aid for being here not only tonight but last month. We really appreciate your public service and volunteering your time and your efforts and your preparation here for this show. Good night. Thank you.